Hey there, folks. Today, we are diving into a court ruling that's shaking up the mental health landscape in British Columbia. The court has declared the province's involuntary mental health treatment scheme unconstitutional, and this decision has some far-reaching implications. You might be wondering, what does this mean for individuals facing mental health crises and the healthcare system as a whole? First, let's set the scene. In British Columbia, like in many places, there's a process for involuntary mental health treatment when someone is deemed a risk to themselves or others. This process involves a legal framework and medical professionals making critical decisions. But here's the twist: the court has found this very system to be unconstitutional, and that's a big deal. Personally, I find it fascinating how the legal and medical worlds intersect in these scenarios, and this ruling highlights the delicate balance between individual rights and public safety. Now, what makes this ruling so significant? Well, it's not just about British Columbia. This decision sets a precedent that could influence similar cases across the country. It raises questions about the rights of individuals with mental health challenges and the limits of state intervention. In my opinion, it's a delicate tightrope walk between ensuring people get the help they need and respecting their autonomy. One detail that immediately stands out is the potential impact on emergency response. If the current system is deemed unconstitutional, how will emergency services handle mental health crises? This ruling could lead to a re-evaluation of protocols, which is both exciting and concerning. On one hand, it might prompt more thoughtful and nuanced approaches to crisis intervention. But on the other hand, it could create uncertainty and confusion during high-pressure situations. What many people don't realize is that this ruling also speaks to a broader trend in healthcare. We are seeing a shift towards more patient-centered care, where individual autonomy and informed consent are prioritized. This decision aligns with that movement, but it also challenges us to rethink how we approach mental health emergencies. It's a complex issue because mental health crises often involve impaired decision-making, and that's where the legal and ethical dilemmas come into play. As a commentator, I can't help but wonder about the practical implications. Will this ruling lead to better training for first responders and healthcare professionals? Will it encourage the development of more community-based mental health resources? These are the kinds of questions we should be asking. If you take a step back and think about it, this isn't just a legal issue, it's a societal one that affects how we care for our most vulnerable citizens. In conclusion, this court ruling is a powerful reminder of the intricate dance between law, medicine, and individual rights. It challenges us to rethink our approach to mental health crises and consider the broader implications of our legal frameworks. So, what's your take on this? Do you think the court made the right call? Let's keep the conversation going in the comments below, and remember, these discussions shape the future of our healthcare system.